Welcome to This Explainer. We're diving straight into a fascinating real-world legal mystery today, one that completely redefined Philippine property law. We're going to look at a landmark Supreme Court case that untangles literal centuries of colonial legal burdens, bringing us to a modern-day legislative rescue. It's a story about a family business, an absolutely impossible legal hurdle, and a perfectly timed plot twist that changed the game for landowners. Let's get into it. So imagine this. If your family has occupied a plot of land for half a century, you've paid the taxes, built a business on it, and literally no one else has ever claimed it, does the state still have a right to just take it away from you? You would probably think, well, absolutely not. No way. But as we're going to see in the complex realm of property law, the answer was incredibly complicated. Let's trace the undisputed facts here. They go back to a company called Pasig Rizalco Inc., or PRCI. They took over a parcel of land that was originally surveyed by Manuel D. Hom way back in 1958, and this was backed up by tax payments dating all the way back to 1956. Fast forward to 2010, the D. Hom Family Corporation, PRCI, finally files an application for original registration of title to officially put that land in their name. Now, we aren't talking about some massive, sprawling, uninhabited jungle here. We're talking about a very specific 944 square meter lot situated right in Barangay Canayagan, Pasig City. It's a fully utilized commercial space complete with a warehouse that PRCI actively uses for its daily business operations. I mean, this place has been a cornerstone of their livelihood for decades. The really crucial point here is that when PRCI applied for land registration in 2010, they had over 50 years of open, continuous, exclusive, and notorious possession. They literally had the neighbors testifying to their presence. They had all the paperwork. There was absolutely zero private opposition to their application. It seemed like a total open and shut case, until the Republic of the Philippines stepped in to oppose it on a strict legal technicality, one tied to the very foundation of Philippine land law. Part 1. The Regalian Doctrine. So, to understand why the government opposed them, we have to look at this doctrine, also known as Jura Regalia. It's a legal concept tracing all the way back to the Spanish crown. Essentially, it creates this heavy presumption that the state owns all lands in the country. Unless a piece of land is clearly, definitively proven to be under private ownership, the law automatically assumes it belongs to the public domain. Basically, this puts the entire burden on the citizen to prove the land is actually theirs. Historically, there's really only one major exception to this massive presumption of state ownership. It's the concept of native title. This was powerfully articulated by U.S. Supreme Court Justice Oliver Wendell Holmes Jr. in the famous 1909 Carreño case. He argued that if land has been held by individuals under a claim of private ownership as far back as memory goes, well, it shouldn't be considered public land. It's presumed to have been held that way since before the Spanish conquest. Expanding on that historical context, Justice Lienen's concurring opinion in our featured Supreme Court case adds some really profound weight. He reminds us that the whole dichotomy between civilized and uncivilized was, frankly, a political device used by colonizers. In his exact words, we are all natives when it comes to ancestral properties. His opinion really highlights the heavy and sometimes deeply unjust hand of these colonial land laws that essentially disenfranchised regular people from land they rightfully cultivated. Part 2. Unlocking Public Dominion. Okay, keeping that historical context in mind, we arrive at the modern legal knot that almost cost PRCI their Pasig City warehouse. You see, under the Civil Code, land falls into two main categories. First, we have property of public dominion. This is land intended for public use or public service. Think roads, rivers, national parks. It is strictly outside the commerce of man, meaning you cannot buy it or own it. On the flip side, we have patrimonial property. This is property the state holds in its private capacity. Once land becomes patrimonial, then it becomes susceptible to being acquired by citizens through prescription, basically through long-term possession. But to actually bridge that gap and cross into private ownership, there was a very strict precedent in place. The old Supreme Court ruling, widely known as the Mala Bananan case, set incredibly high hurdles. An applicant didn't just have to prove the land was alienable and disposable, meaning the government has certified it's suitable for private ownership. No. They also had to miraculously produce an express government declaration stating the property was no longer intended for public service and was officially converted to patrimonial property. As you can imagine, this placed an almost impossible burden on ordinary citizens like PRCI. I mean, think about it.
They were essentially being asked to prove a negative fact. They had to show that the state lacked the intent to use a tiny 944 square meter lot that the government had never, ever occupied in the first place. Since the state never used it, well, the state obviously never bothered to issue an official declaration abandoning it. It was a complete catch-22.
Part 3. The Plot Twist, Republic Act 11573. So, before this massive twist, the old property registration decree actually required citizens to prove they had possessed the land since June 12, 1945, or earlier. I know, wild, right? But then, Republic Act No. 115073 swooped in and dramatically lowered the barrier. It replaced that almost impossibly distant 1945 hurdle with a much simpler, highly practical requirement, just 20 years of possession immediately preceding the application.
And the timing here? Entirely serendipitous. This new law, RA 11573, officially took effect on September 1, 2021. And this happened right in the exact middle of the Supreme Court's active deliberation on PRCI's specific case. Because this new law was essentially a curative statute, meant to fix past errors and simplify the process, the court ruled that it could actually be applied retroactively to pending cases. Talk about a lucky break.
But the absolute crucial point of this new law isn't just the shortened time frame. It contains this sort of magical phrase. It says that 20 years of possession on alienable land means the applicant is conclusively presumed to have performed all the conditions essential to a government grant. This single, powerful line totally eliminated the need for that impossible express declaration of abandonment from the state. If it's classified as alienable and disposable, and you've possessed it for 20 years, it is open for private acquisition, period.
Part 4. The final verdict.
So, let's bring it all back to PRCI and their warehouse in Pasig City. Remember their uninterrupted tax payments and possession dating back to 1956? Well, that translates to an astounding 54 years of ownership prior to their 2010 application. That completely, utterly obliterates the new 20-year threshold set by RA 11573. They had more than proven their long-term, continuous, and exclusive possession. But the Supreme Court didn't just stop at PRCI here. They used this landmark case to lay down clear, actionable guidelines for all future applicants under the new law. No more guesswork. To prove land is alienable and disposable today, you need a duly signed certification by a designated DNR geodetic engineer, literally imprinted on the survey plan. It must reference the specific administrative order classifying the land, and it has to include the land classification, or LC, map number. And most importantly, that engineer must be presented as a witness to authenticate it. Ultimately, the Supreme Court beautifully resolved this decades-long mystery. They officially affirmed PRCI's undisputed 54-year possession. But because the rules for proving the land's classification literally changed while the case was pending, the court remanded the case down to the Court of Appeals. The sole purpose of this was just to allow PRCI to simply submit the newly required DNR geodetic engineer certification under these much easier, modernized rules. This case really is a monumental shift. By stripping away those impossible colonial-era burdens and simplifying the rules, the law is finally aligning with reality. It empowers everyday citizens to secure what is rightfully theirs. As the system finally shifts to correct these historical burdens, it leaves us with one really powerful thought to explore. As you look at the land your family has cultivated or built upon, who truly owns the history beneath your feet? Thanks for joining me for this explainer, and keep questioning the ground you stand on.